We're now continuing with our very interesting discussion on AI, the adoption of technology, market trends, and we are joined by Jacob Turner of Fountain Court Chambers. So yes, just looking forward to continuing to discuss the issues.
So Jacob, we've talked quite a lot about the UK the courts and the judiciary and also what the government are doing. We thought it would be interesting to just look a little bit further afield and see what's happening elsewhere, and I suppose for the UK's purposes, the two sort of greatest allies and sort of trading partners are the EU and the US, so maybe starting there. The EU 27 obviously came to a sort of draft understanding of an AI Act in December of last year, recently sort of hit the statute books I think in March of this year, and it's a kind of risk-based approach, classifying, regulating risks and systems. So at least for the time being, perhaps a stricter approach than we've got in the UK. In America, I think President Biden had an executive order for sort of government departments and looking at safety and security around the time of the Bletchley Summit as well. So I suppose, do you have any insights further to what we've discussed about what's happening in Europe or America in contrast to what's going on in the UK in the regulatory space?
The UK sits somewhere between Europe and the US, both geographically but also, more importantly, in legislative terms with respect to AI. The executive order is very detailed and perhaps surprisingly far-reaching in terms of its ambit, which looks at constraints on the most powerful systems, mandating testing, restricting the ability of parties to export those systems to nations which might not be friendly to the US, as well as a whole host of requirements with respect to civil liberties, which are more of a concern for a democratic administration than might perhaps be the case for a Republican administration, albeit that there doesn't seem to be a great deal of disagreement in the US as to the subject matter of the executive order. So it is interesting to see that the US has been moving forwards on that, despite being, generally speaking, a reasonably light touch regulatory jurisdiction when it comes to new technologies. And of course, as you've mentioned, the EU has now, in very nearly final form, an extremely detailed piece of legislation on AI, treating it basically like a dangerous product that needs to be regulated throughout its life cycle.
I think parts of that are due to be coming into force this year, I think, or in terms of implementation, or is it staged implementation?
It's a staged implementation. It hasn't yet been published in the official journal, but then when it is, there will be stages from around 6 months going up to 2 or 3 years for other parts of it, albeit that there could yet be some changes in the text between now and its finalisation, but I don't anticipate them to be very significant. Businesses are going to need to comply with these things even before they officially come into force, because you will be building the technology prior to the date on which the legislation actually starts to bite. And if on day one you're not compliant, then you're not going to have further time to comply. You need to comply from the date on which it sets in. So the compliance piece has started already, and I'm already starting to see clients now saying, what do we need to do to bring our technologies that are already in use, or ones which we're starting to develop or buy into compliance with the AI Act. The one other area that I would mention is with respect to Chinese regulation. This is, I think, perhaps an underappreciated source of regulation in AI. But back in 2017, China, as part of its National AI Development Plan, announced that it wanted not just to be a world leader in the creation of AI technology, but also a world leader by 2025 in creating rules around AI technology. And it has already enacted, in fact beating the EU to it, several pieces of legislation with respect to AI. It has a piece of legislation concerning algorithmic recommendation systems. It has a piece of legislation relating to generative AI. And these pieces of legislation are, generally speaking, more or less in line with the requirements that are being set by the EU. So there is a degree of global consensus as to the substantive requirements for AI systems. And for any global business that is looking at operating in China and also within countries that are part of China's Belt and Road Initiative, where it seeks to create a degree of soft regulatory compliance and harmonisation across those countries, that other source is also going to be significant and important.
Yeah, absolutely. I suppose, as you're saying, if you're looking to operate as a global company, you're going to have regard to what it is that you need to do. So it's about that looking further afield piece. So interesting.
And Jacob, just coming back to your really helpful points on the EU Act, when you're talking about sort of clients, having to get to grips with those regulations, is that UK clients who have any dealings with the EU, or is it just if you have sort of a base in the EU? What's the sort of extent of the regulations?
The EU AI Act will be extraterritorial in a similar fashion to the GDPR.
Yes.
One of the criticisms of lots of EU regulation is that it places impediments on EU businesses and could place them at a competitive disadvantage. That's certainly been levied against the AI Act, to which the EU legislature will respond, okay, we'll just make this something that everyone has to comply with globally, by making the territorial effect of it extremely broad. So whilst there does still need to be some degree of connection between the deployment of the technology, the development of the technology, the use or even the effects of that technology within the EU, those links are pretty loose ones, and ultimately any sufficiently global technology company, or indeed a company which is not a technology company but just uses AI as part of its business processes, they are going to have to think very carefully about EU compliance. So it's not just businesses that are based within the EU that are developing their AI within the EU, it's very much businesses around the world that are going to need to think about and to probably start to comply with the EU AI Act, even where their connection to the EU is minimal.
And moving away then from that sort of legislation piece, in terms of, and obviously we've already discussed the Thaler case earlier on this morning, but are you seeing, Jacob, sort of any trends in case law, particularly from the US, and around sort of IP, privacy, copyright infringement concerns? I just wondered if we could sort of, or you could give us your thoughts on that, and whether, to what extent we're going to see that trend continuing to develop in this jurisdiction.
Copyright and other types of intellectual property protection are certainly the key area of focus at the moment, driven in large part by the way in which large language models have been trained, which typically involves the scraping of enormous amounts of data from different parts of the internet. Sometimes specialised databases like Leon, which has been used to, at least in part, to train many of the large language models, but sometimes just from the internet more generally, looking at all sorts of sources. The rights holders, the people who have generated the relevant content, clearly have a very significant economic interest in protecting that content.
Absolutely.
And dissuading people from using it without permission, or trying to exact some kind of a license fee for using that content.
There's always an opportunity.
Well,
but as there should be,
indeed.
In terms of the ownership of that material.
Absolutely, and so there are clear economic incentives to bring litigation, to commence claims against the companies who have been training AI and who stand to benefit extremely significantly from the creation of those AI programs. So I would say that is certainly a clear trend that one can observe now, particularly in the UK and the US. There are differences and nuances between the UK and the US approaches to copyright. The fair use doctrine in the US is potentially broader than that which is allowed for under UK and ultimately EU law, from where much of UK copyright has been derived. So that the jurisdictional differences in terms of the treatment are going to be significant. It's also worth noting that there are jurisdictional differences in terms of the protection of copyright. So not just the exceptions, but whether copyright applies in the first place or whether there is an infringement in the first place. Certain jurisdictions like Japan and Singapore have legislated to allow for the use of text and data mining, essentially these scraping activities, as a recognised exception to copyright. So you won't have infringed copyright at all if you use people's material for training your AI. And those differences between jurisdictions could, I think, have a major role in shaping the way, not just in which the litigation goes, but also the way in which, commercially speaking, AI companies choose to train their models. And in this regard, one of the defences of Stability AI, the company behind Stable Diffusion, which is one of the defendants to a claim in the UK, one of their defences is that they didn't train their AI within the UK, and accordingly they say they don't fall within the ambit of UK copyright protections.
So, Jacob, we thought we would move on to talking about industry trends and sort of what's going on the ground within various sectors, including our own. We thought we'd start with an article that you co-wrote in December of 2023 with, I think, Tristan Goodman, entitled Professionalising the AI Industry. And I suppose thinking back to what we were saying earlier about Bletchley and how the UK was sort of positioning itself as a global leader in AI, I think you make the argument within that article that we're also in a good place to sort of, in the AI sector with professionalising our professional services, again as world-leading services. So could you please expand on the sort of themes and points you raised in that article?
Professional services is the UK's biggest industry. It's our largest export. We are the second largest exporter of professional services in the world after the US. So it is an enormous success story for the UK, and it's somewhere that we have a comparative advantage in. Now, people don't come to UK lawyers, to UK financial services institutions, to UK accountants because we're unregulated. They come to us because we are very highly regulated, and from that regulation you can trust that the services that you will get, by and large, will be of a high quality and that there will be a degree of professional integrity to everyone that you deal with in that industry, and that unethical practices will be spotted and will be eliminated or penalised. So that, in broad terms, is the reason why we have professionalisation, to enable members of the public to trust in potentially dangerous, potentially harmful industries where there is a degree of complexity and a degree of opacity, so that people can't easily judge from the outside whether somebody is doing a good job or not. You need to rely on the regulation to do that. I suggest that AI has all of those hallmarks in terms of its development. Potentially very harmful, obviously potentially very beneficial, difficult for outsiders to be able to evaluate and to interrogate, and of course it's very complex in terms of how you go about setting up an AI system. I think that the UK, and indeed the wider world, could therefore benefit from professionalising the AI industry, from requiring those who are involved in a material way, at least for commercial purposes, in the development of AI, to be regulated in the same way as we regulate lawyers, doctors, accountants, dentists, airline pilots, vets, and so on. So that's the basic argument that I make. I suggest that the UK has the ability to do this. I think it is an area that hasn't had as much focus upon it as perhaps it ought to have done in the last few years, where there's been lots of discussion of AI regulation. And I also think it's an area where the UK could play a leading role in terms of creating the institutions that other countries around the world may wish to match moving forwards.
Absolutely. No, I agree with that. And I suppose moving on, you've talked about the legal sector and how highly regulated as lawyers we are. So just thinking about AI and its use within the legal sector, a recent Oxford University report suggests that over half of solicitors, half of lawyers now adopt AI law tech in their daily working lives. The technology they found was substituting things that previously perhaps more junior lawyers were doing, but it was augmenting the roles that those fee earners were doing as well. It suggests that we're not sort of at the edge of a sort of major reformulation of law firm business models quite yet due to AI. But actually some interesting trends that came out of the report was some of the things that now interest lawyers, such as data analytics, sort of innovation techniques, project management, even coding, skills that perhaps 5, 10, certainly 20 years ago lawyers wouldn't have sort of touched at all. And so I suppose following from that report and linking back to your article, do you think lawyers are becoming sort of new technologists in the 2020s, and is the role of a lawyer going to sort of change dramatically for the new joiners to the profession in the coming years?
I think some aspects of the legal profession are going to change significantly as a result of the advent of AI. Certain functions, for example, the review of tens of thousands of documents, which is something that has increased significantly as a result of the use of digital document creation techniques, so the internet and email, which has massively increased the amount of both information created but also the ability to easily search for it. I think that has probably hit a high point in terms of junior lawyers and paralegals spending enormous amounts of hours. I think the trend going forwards is going to be that will increasingly be done by AI systems, and that will increasingly be accepted. There are, however, other areas of the legal profession which have historically only been possible to undertake by human intellectual activities. For example, the creation of arguments, the drafting of pleadings. Those things, I think, will also be amenable to AI usage and AI augmentation, as you mention. And over the coming years, I think we will increasingly see not just the commoditizable, fairly low-level work being undertaken by AI, but actually some of the more complex work involving legal reasoning, involving the application of principles to fact patterns, working out the most salient arguments. I think increasingly that will also be done by AI.
I suppose the question that follows on from that, what is left for the lawyers to do after all of that?
The impact of technology on law is something which we have always had to deal with up to a point. When photocopiers came to be used, the role of people who typed out letters, or scribes, I suppose they would have historically been, died out. So there have been elements of the legal profession or ancillary roles that have come and gone over the years due to the advent of technology. And I think that's not something which is in itself new. That said, the move into the legal reasoning aspects of the lawyer's profession, I think that is something which will fundamentally challenge what it is that we do as lawyers. Although, going back to a point that I mentioned earlier, the two barriers in addition to the technological capability, those being the psychological or cultural reasons for not taking something up, as well as the regulatory ones, I think those will continue to some degree protect existing lawyers from the full impact of those points, as has been the case, generally speaking, in terms of law as a regulated profession protecting itself from outside competition that might otherwise come about in terms of people who might wish to be advising on the law but who are not within the regulated profession. So I think the regulatory side of things will be something of a barrier, at least until that regulation is reformed to allow for greater use of AI, which may be a good thing ultimately for clients, but maybe a bad thing for lawyers.
I think it's picking up on a couple of things that you've said there, Jacob. I think sort of for me it's that whole, is the technology there, that ability to rationalise, I suppose. We can, and I very much agree with Jacques, where it's a case perhaps of it's augmenting function and processes and tasks, and actually that perhaps that presents an opportunity for clients, for employers to actually upskill their workforce, simply because you can actually have your staff, your human staff, pointed in a different direction or doing a different part of the task, and they can get to do that analysis piece. And again, whether that's equally assisted by AI technology, they can get to do that sort of more quickly in whatever transaction or whatever deal or whatever process an employer is engaged with, I think. So, I mean, in terms of us, we've touched on it earlier today, but in terms of issue spotting for us as lawyers, I think we have to think about how we might adopt that technology as practitioners, and equally advising clients as to how to best deploy that fast evolving technology in their businesses, I really think. And that might be sort of, potentially contentious uses of AI generated text and imagery, and we've already sort of seen that come into play in terms of the Screen Actor Guild strikes relating to control and compensation for uses of digital likenesses. I think we here at Rosenblatt sort of do continue to envisage it being a stream of sort of advisory work, centering on issues such as risk management, clients' appetite for risk, a loss of control, being able to deploy technology to perhaps really sort of manage process, and what that might mean for an employee's or an employer's workforce, and maybe some advisory work around those sort of issues. And again, it's about the importance of that verification piece, really. So about the safe use and deployment of the technology, and what you can do to ensure that what a client is putting out there, reputation management equally, is verified content. So probably, if you had anything to add to that list, it'd be great to hear.
I think that's a very comprehensive list of the things that clients need to be mindful of. Perhaps the one thing that I would add, based on my experience, is regulatory engagement. So often clients will be concerned about interfacing with a regulator. They don't necessarily want to put themselves above the parapet to bring themselves within the regulator's crosshairs, and to perhaps inadvertently generate some kind of an investigation into their practices.
Notes of caution, yes.
Indeed. But with AI, I think there are significant opportunities for clients, in part to obtain regulatory comfort and guidance at an early stage, and also to market what they would like to put forward as good levels of compliance, and to try to persuade the regulator and try to shape the regulator's approach.
It's about having a seat at the table, I suppose.
Exactly. And my experience of regulators in the UK and indeed in other jurisdictions with respect to AI is that they are really keen to hear from businesses, because the regulators are trying to upskill.
They're trying to grapple with these issues. So
they're trying to work out what their parameters ought to be, how to apply their existing regulations to AI, and they really like to hear from businesses as to what's working, what isn't, what techniques are being adopted,
and that will be different in different sectors.
Exactly.
So I think it's one of it's for us an interesting issue simply because it applies to all, ourselves included. It applies to everyone. Whilst there are differences, it's applicable. It's something that's relevant for every sector.
Absolutely, and I think lawyers can play a very valuable role in moderating those conversations, in presenting their clients' positions and their clients' techniques to the regulators in as compelling a way as possible. Because ultimately, this is a piece of advocacy.
Of course.
But fortunately, it is a piece of advocacy where you don't necessarily have the same threats as you might do in litigation or some other kind of dispute.
Yeah.
So I think that kind of proactive approach to AI compliance is something which should be seriously considered by clients.
Yeah, that's very interesting.
And I suppose just following straight on from that, our own regulator, the SRA, Solicitors Regulation Authority, I think in November of last year, issued guidance very similar to His Majesty's Court Tribunal system, sort of talking about accuracy and bias and client confidentiality. So it's only recent guidance, and it's still sort of trying to kind of feed through into the law firms. And so it's, as you say, a kind of collaborative process with the SRA and law firms. I'm sure they would want to hear what's happening on the ground and how things are being played out in reality.
Yes, exactly. And I think what the regulators don't like is parties trying to hide what they're doing from the regulators, because that then gives rise to suspicions. Now, obviously, in some circumstances, businesses won't want to display everything that they're doing to the regulators. It may be too risky to do so. But I think particularly in a very highly regulated field like that of the law, where it's absolutely important that you don't step out of line and the consequences of doing so could be extremely severe, that is a situation where it is all the more appropriate to speak to regulators if you're adopting a new technology that you're not necessarily sure about, or that you might want to make sure that you've mitigated the risks, but you're not sure that you have done. That's a good point at which to speak to the regulator.
Yeah.
And I suppose exactly it's that early engagement piece, which I think is an excellent point, because there is information out there as to how different companies in a range of sectors are essentially engaging with their workforce about the use of AI and how the use of AI may be being undertaken by their various employees. For instance, there was some information that I got about the development of Briefly, and that's something. It's a beta version of an AI tool which Saatchi and Saatchi are using, and it sort of fast tracks the writing process of creating brief. So again, that jumping off point. Catherine Parsons is an entrepreneur behind a technology education company called Decoded, and Decoded are working with companies across sectors such as City and HSBC, all the way through to Christie's the auction house, to help those entities, those companies, navigate potential pitfalls and use AI to their best advantage. So another example is Aviva, who I think have said that their stated aim is to actually upskill employees. So even though there might be the acknowledgement of some replacement of parts of job function, it creates an opportunity to sort of co-create new roles for individuals. And so again, there's that whole advisory piece about the speed at which that automation is happening across a range of sectors. So I think that information is or can be gleaned by a regulator, as you said, an early stage.
And I suppose just coming from the sectors themselves to individual companies and workplaces, I think we're seeing a little bit at the moment that some workplaces are putting in place policies in the same way they might have a sort of annual leave policy or a dress code policy. Mm-hmm. I suppose to the extent companies don't have this, maybe small companies it wouldn't necessarily apply, but medium and larger companies may have these policies in place, or at least be thinking about them. What sort of things, in addition to what we've discussed, do you think should be in place, and do you think there needs to be a kind of clear process of reporting to senior staff where there are things like deepfakes and hallucinations and things of that nature to kind of report in a clear way?
Every company which uses AI in whatever field ought to have some kind of internal guidance around that AI use, as well as governance and controls. As you identify, there is going to be a proportionality aspect to it. Companies which only use AI in a relatively low impact setting would not need to have as detailed governance and controls and policies on this as companies which are using AI in a more impactful setting. But in broad terms, I think the way in which we ought to think about AI is similar to the way in which we now think about data protection. It is an absolute essential that companies, whatever their size, if they're using personal data, which pretty much all companies will be, whether it's internally or externally, they must have data protection policies, they must have data retention policies, they must have data protection impact assessments, they must have records of processing activities, they must have sub-processing agreements if they're outsourcing any data. So all of these suite of documentary and indeed substantive requirements that we are now very familiar with respect to data, that's the sort of thing which I think we're increasingly going to need to see with respect to AI. And bear in mind that with data protection, those requirements didn't exist, or certainly if they did exist, they weren't being adhered to before the GDPR came into force in 2018. That sort of a change in outlook is going to be needed for all types of businesses. And because AI is now able to take decisions that only humans would previously have been able to take, or at least to make recommendations where humans will take the ultimate decisions, the impact, I think, will be far greater than in data, which ultimately is just a collection of information and the extent to which one processes that information. With AI, the impact on businesses and the way in which they're run, and also the risks that come about through that AI use, those are going to be far more significant. And so I think it is sensible for all types of businesses to try to mitigate against those risks from a very early stage. Certainly from my experience in seeing some regulatory enforcement actions in this regard, it's the businesses that have those procedures in place that are likely to be able to defend successfully against any regulatory enforcement, whereas the businesses that have done nothing to justify their AI use, to put it within established parameters, they will find it far more difficult to explain how they have complied with what can be quite vague regulatory obligations, like a requirement of fairness, for example, which one sees a lot of regulators seeking to apply in the AI field.
So once again, be proactive.
Yes, exactly.
So just with a view to wrapping up and thinking about some sort of final concluding thoughts arising out of our discussion today, I think there are certain of key themes that we've sort of discussed between us. You know, what is that humanness element, the replacement of original thought, and perhaps that's informing people's receptiveness to the adoption of technology, which I think we all recognise is undoubtedly here. To what extent humanness is required, and whether a large language model can really produce anything that's sort of worthy of that sort of human creativeness analysis piece that is sort of said to precede the invention of a unique piece of work. So in short, might creativity be a dying art, and how we can adopt that and embrace that and use the technology, but in a sort of verified, sort of risk-based managed approach, I suppose. That would be sort of, you know, some initial thoughts that I had. Jacques, I don't know if you
and I suppose
to add to
just
that.
two further things on the sort of humanity of it all, and sort of creative thinking and emotional intelligence. Are we still, you know, a little way away from machine learning being able to kind of duplicate those very human sort of characteristics?
I think as ever, sort of one looks to data to sort of rationalise sort of, you know, what is going on in the current picture. And something I think I just wanted to pick up on in as part of our concluding remarks was that the 2023 World Economic Forum Future of Jobs report saw that organisations actually estimate that 34% of all business-related tasks are performed by machines, with the remaining 66% carried out by humans, and that represented only a 1% increase on the same figures in a 2020 edition of a report which bore the same name. And I think to add to that, further respondents actually downwardly revised the prediction of proportion of tasks likely to be automated within the next 5 years from 47% to 42% since the last survey. So, you know, just I don't know whether that, again, there are sort of cultural concerns behind that piece, but it's just interesting to sort of put that into context, the wider context of what we've spoken about as to what this technology is capable of and how we all might have a part to play. Jacob, I don't know if you sort of had some final wrap-up thoughts from your perspective and as part of our discussion today.
There is a well-known paradox with our relationship to technology, that we tend to overestimate its impact in the short term, but underestimate its impact in the long term. And there's probably a degree of that with respect to artificial intelligence. That said, I don't think perhaps 10 or 15 years ago any of us would have thought that perhaps within our working lives we would see AI that's capable of generating entire films, of writing entire scripts, of creating new music and new artwork, and indeed creating new computer programs or components of computer programs. That very much would have been within the realms of science fiction rather than fact.
Yeah.
So the extent to which the technology has improved over the last 10 years has been extraordinary, and I think people are right to observe that it will profoundly change the way in which we live. And ultimately, as lawyers and as people involved in the commercial world, the extent to which laws and regulations and principles need to be changed and updated to fit with that new technology and to meet the challenges which it gives rise to, that is something which is going to keep us busy and occupied, even if certain aspects of our day-to-day working lives are being taken up or being replaced by those AI functions.
And it's interesting what you say, that underestimation, overestimation point. Maybe that's just human nature. So there we have it. So Jacob, I think both Jacques and myself would very much like to thank you for taking part in our discussion today. Thank you for your time, and I think it's been an interesting exploration of the issue, so thank you.
Thank you very much.